Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Today we have a very interesting issue. Issue that is raised is if your ex takes assets during the marriage, puts them in his parents' name, are you able to recapture them as part of the divorce settlement? Well, it's a very good question because, you got to figure out why. The why is going to be pretty important in this case. If, for example, you knew that he was doing that and there was some reason that benefited you, you might not be able to argue that you were fooled and you're entitled to it and blah, blah, blah. In other words, if you're approaching it with that, remember one thing, the courts are courts of equity. So principles of equity are going to govern. If you had unclean hands in something because you knew that something was being done, let's say assets were put in your in-law's name because you were trying to hide them from your creditors, and now you want to say, well, yeah, they're in their name and I'm not legally entitled to them, but this is a divorce, I want them back. It's going to be challenging to divest them of those assets, especially depending on what they did with them, if you were involved. If you did it that way to avoid, a creditor, or you don't have clean hands in the situation. On the other hand, if you didn't know about it, if your ex took assets and deliberately hid them from you by giving them to the brother or the mother or somebody else so that you could not get them, so that you would not have access to them in the property settlement during a divorce, you can well expect that the court might very well decide, you know what, those are fraudulent transfers, I'm setting them aside. But it's going to be tricky. The longer you allow that to go on, the longer these assets have been in the name of somebody else, the harder it's going to be for you to unravel it. Now, if you didn't know about it, you didn't know about it. But, logically, you buy a house and it's not in your name. So the tax bills are coming to somebody else. The mortgage notes are going to somebody else's name. How do you not know about it? Maybe you didn't know about it. Maybe it was too new. There could be reasons why you didn't know about it, and the court will take that into account. Remember the overlying principle. There is equity, fairness involved when we analyze the distribution of property in a divorce. The court's going to see what's fair. If the court sees that you deliberately transferred an asset to hide it from your ex, the court's going to set that aside or take whatever steps can be done to set that aside within the law. On the other hand, if you were a willing party to it and it benefited you, you're not going to be able to come and claim you didn't know about it and therefore it should be set aside. You gave this asset to avoid your own creditors. Had you not done that, the creditors would have taken it and the asset wouldn't exist anyway. So why should you be able to benefit from it now? So in other words, there's an analysis that's going to go underneath to determine what's the undertone of this case, what has actually happened behind the scenes, and that will very much dictate how the court reacts to it. If you have any questions about that, reach out and we'll be glad to help you out.
248-588-3333. 248